Testing, testing. right, so welcome to the Public Service Commission's administrative meeting for May 14th, 2025. First item is to approve the minutes from our meeting of May 7th, 2025. Commissioner Linton.
Aye.
Commissioner Sussman.
Aye.
Commissioner Barvet.
Aye.
Commissioner Richard.
Aye.
I vote aye.
Good morning, Mr. Chair. There are 5 items on today's consent agenda. The first is from Delmarva Power and Light. It's designation of weather stations in compliance with COMAR, Section 20.31.03.05. Item number 2 is Arise Energy LLC. Its application for license to supply gas or electric supply services in Maryland. Item number 3 is the Potomac Edison Company. Its revised tariff pages to update its electric supply rates for Type 1 SOS and Type 2 SOS. Item number 4 is from Bollinger Energy Corp. Its request to withdraw its residential licenses in Maryland. And item number 5 is from Maryland Energy Advisors LLC. Its request to modify its licenses, IRS numbers 1954 and 2825.
Okay, regarding item 1, I move we approve the change in the company's designated weather station for determining when there is an extreme weather period that requires restrictions on electricity service terminations under COMAR 20.31.03. Commissioner Linton.
Aye.
Commissioner Suchman.
Aye.
Commissioner Barvet.
Aye.
Commissioner Richard.
Aye.
I vote aye. Item 2, I move we grant the company a license to operate as a natural gas supplier in Maryland, limited to broker services for the customer classes and service territories applied for and recommended by staff, and direct the company to notify the commission within 30 days of any changes in the information of its application. Commissioner Linton.
Aye.
Commissioner Suchman.
Aye.
Commissioner Barvet.
Aye.
Commissioner Richard.
Aye.
I vote aye. Item 3, I move we accept the tariff provisions for filing with an effective date of June 1, 2025. Commissioner Linton.
Aye.
Commissioner Suchman.
Aye.
Commissioner Barvet.
Aye.
Commissioner Richard.
Aye.
I vote aye. Item 4. Well, actually, so why don't we start with you and then we'll flip over. Sure.
Good morning, Chair and Commissioners. Charles Herbert on the behalf of staff. Item number 4 on the consent agenda is a request from Bollinger Energy Corporation to amend its natural gas supplier license to no longer include permission to serve residential customers. Staff reviewed the instant filing and determined that, as Bollinger's request is a request to modify its license rather than cancel it, the company will remain licensed and will continue to pay commission assessments and remain subject to commission authority. The company confirmed in its filing that it had terminated service to all of its residential accounts in Maryland as of April 1st, 2025. Accordingly, staff recommends the commission grant the company's request. Staff has read and reviewed the comments filed by the Maryland Office of People's Counsel, and Ruthie Herman, Assistant Staff Counsel, would like the opportunity to rebut OPC's statement in this matter. Thank you, and staff is available for any questions.
Okay, so any questions for staff? Okay, Commissioner Suchman.
So, Mr. Herbert, I understand that they're modifying a license.
Correct.
But what's happening to the bond?
They don't have a bond. When they applied a few decades ago, they had passed the accounting division's financial integrity test, and as a result of that, they were not required to submit a bond.
They were an electric supplier several decades ago.
Commissioner Suchman, hi. Ruthie Herman on behalf of staff. I wanted to just reply for Mr. Herbert. The law is still the same now in COMAR. There is no requirement for a bond. The law currently says, and it's similar to what was in place when this entity applied, you have to pass a financial integrity test. Now, COMAR presently says and this is 20540208. Following review of the statement, I just want to make sure I can be heard. Following review of the statement of financial integrity provided by the applicant, the commission may require a bond, letter of guarantee, or other financial instrument from the applicant, applicant's parent, or other responsible person. The language was slightly different 20 years ago. I did do some research into the
Okay, so it looks like as of 2001, they became a licensed supplier. At the time, and at the time, you didn't require a bond. For suppliers coming to you now to seek a license, you require a bond.
It's the okay, yeah.
Kevin Mosier on behalf of staff. It's been the same basic policy for about 25 years. If you pass a financial test, which most suppliers don't, then you have to get a bond. But if you pass that financial test, a bond is not required.
Okay, and then what happens if there's some financial issues with the company in the succeeding years, and so they would not be able to pass a financial test now? There's no recourse for you to require a bond. It doesn't seem. I mean, if there's a problem with the supplier, there's no protections for the customer, for the ratepayer, if there's no bond.
And thank you, Commissioner Suchman, Ruthie Herman again. And there is no direct consumer relief in the bond. COMAR sets forth what the bond shall say. And we brought with us some examples, too. Could Charlie Herbert approach the Executive Secretary and distribute for the bench some copies of some recently issued bonds? So COMAR says that the bond shall say, and this is 20510208. A bond shall identify the PSC as the sole beneficiary, be continuous and subject to cancellation on 60 days' notice, unless for good cause shown, Commission orders otherwise, contain the following language, or similar language acceptable to the Commission. Payment under this bond shall be due if the Commission determines the entity is financially insolvent or unable to meet its obligations, or ordered by a Maryland court after a person who has obtained a judgment against the entity has previously attempted to collect the judgment through all other means available to the court. So we just want to emphasize to this bench that there is no direct consumer relief in the bond.
No, but there is, if the consumer has a judgment against the entity, then it sounds like the consumer can have some recourse from the bond.
I'm so sorry. May I ask you your
That's
question?
all right.
Yeah, I'm so sorry.
I know. I there was a lot of so if the consumer has some recourse against or some action against the supplier, and the supplier is insolvent, if there is a bond, then it sounds like the consumer can seek recourse from the bond.
Indirectly, the
Right. But there is some avenue for them to be made at least partially whole. I mean, we don't know what the judgment would be, but in the absence of a bond, there's nothing that the consumer can attach.
So I'd like permission to answer you this way. Let's consider the facts here. Bollinger only had 49 residential customers, and they were transferred to SOS as of April 1. Let's just say, for sake of argument, that each customer had a successful claim in district court in Maryland for $200, and each customer was able to submit the facts that they were justified, for this $200. That's $10,000, and that's in the extreme example that each
Yeah, but I'm actually less interested. I mean, I'm interested in that, but the concern I have is that there every week we have some sort of nuanced way of suppliers avoiding having to have a bond in place. So this is a new approach, is that they were going to modify their license as opposed to getting rid of the license. And then next week we're going to have something else. And so I worry that at the end of the day, it's the ratepayer that is going to have no recourse if there's no bond in place. And it doesn't matter that there are 49. Next week there could be 4,900. I mean, this keeps every week we keep having sort of a new take on ways in which a supplier is going to avoid having to have a bond in place. But I'm more interested in. I mean, it almost seems like there's sort of a grandfathering in now for natural gas suppliers that have had their licenses for an extended period of time. Am I wrong in that?
No, Commissioner. Well, Commissioner, as Mr. Mosier said, there isn't actually a requirement to get a bond for a company that passes the financial integrity test. Now, I suppose we got wind of a company, having financial difficulties, then, we could go back and ask for one. But,
But you may not know. I mean,
we may
and
very well not know, but that it remains the case. I mean, we do not automatically require a bond. The intent was for the companies to pass the financial test if they possibly could.
Right.
And if they did, then they weren't required to get a bond. And that was not just gas suppliers, that was even more so for electric suppliers, which also have the ability to not get a bond if PJM gives them a certain amount of unsecured credit.
okay, so at this point, this is an entity that is licensed for electric and gas, and doesn't have a bond.
So, Commissioner, they do have an electric license, but that is a broker license only, and it's only for commercial and industrial customers. So for that license, they do have a $10,000 bond.
Okay.
However, their gas supplier license, which is a full supplier license as opposed to broker license, which includes residential customers as well, that is the license they do not have a bond for.
Okay, and they don't want to. They want to keep the license, but they don't want to supply residential customers.
They do not want to have the permission anymore to be able to serve residential customers.
So-
Correct.
Actually, let me ask something about this. So it does strike me that Commissioner Sussman's correct. I mean, it seems like this has been a weekly exercise now for a couple of months. And I know this is all a result of SB1, and we're all trying to figure our way through all that. So I guess what I'm wondering is, should we maybe send a notice to all of the retail suppliers to say, look, if you want to get out of the residential customer business because you don't want to adhere to the requirements of SB1, you should send us a notice, and why don't we try and deal with all these things at one fell swoop instead of this sort of dribbling through these things, for the next 6 months.
We can certainly do something of the sort, Commissioner. I think you had actually asked us to work with OPC to try and come up with
Right, yeah. I
a
remember
way
that.
of addressing this.
But now, because it seems to me it's now being driven by the various companies, I guess, discovering or figuring out that, we don't want to live under SB1, and so, we're going to dump our, residential customers, and then we go through this whole thing about, well, who's going to be left holding the bag if you guys, dump these customers and there's some problem. So I guess what I would rather do is let's send a notice out and force their hand, make a decision. If you want residential customers and you're willing to live under the prescripts of SB1, great. If you decide you don't want to do that and you want to get out of this business, then fine. Send us a notice, and then at some point we'll have a proceeding where we just deal with all these instead of doing this on, for the next, 6 weeks or so.
It may be that the most appropriate action in that instance would then be to do something like a rulemaking to.
Sure, yeah, I understand, so.
Omar.
All right, so why don't we do this? Let's, we're gonna defer item 4 and not, and tell Bollinger that, just to sit still and we're gonna figure this out at some. Okay, sure.
So the bond is between the Public Service Commission and Bollinger, correct?
If there were a bond,
If there were a bond, it would be between, okay. So let's just say for the sake of argument that something untoward happens and a bunch of their prior customers do have a complaint. What would be their recourse if there had been a bond? How would the recourse have worked its way through the system? My impression is that we would have had to stand in the shoes of the ratepayers and basically try to make the ratepayers whole by us going after the bond. That's the way it would work, wouldn't it?
well, there are actually two methods of recourse in the circumstance you outlined, because as Bollinger is not leaving; they're still here. They remain. They're not. They're not getting rid of their license. They're intending to continue serving commercial and industrial customers. So the first recourse would be to file a complaint here and get direct relief. And as long as Bollinger remains in the market
Okay.
in any capacity and subject to your jurisdiction, there is no
We can still go after
issue
them.
with that. Now, if it got to the point where Bollinger left the market entirely and asked that their license be canceled, and and you wanted to rely on a bond, or make them get a bond, if they had the bond and it had the standard language in it, a customer would have to go to court for whatever amount of their claim is, and it would probably be a small claim. Then they would have to get a judgment in the court. Then the court would have to use the court's various mechanisms to get relief. To actually get the judgment paid, and only if that failed could they come back here and ask the commission to draw on the bond.
Okay, so now let's examine the situation as it exists right now. There's no bond, and let's say there are ratepayers who are owed. Let's just say one ratepayer is owed $200. The court finds in her case a $200 judgment, and Bollinger refuses to pay it for whatever reason. Then we, as the commission, would have to go after them. Correct? We'd have to stand in the shoes of the ratepayer to try to get that $200. Is that
If there weren't a bond, the commission would actually be out of it at that point. If there were a bond in place, then yes. So remember, Bollinger doesn't have a bond right now.
Yeah.
So in that situation, if they were out of Maryland altogether, in that.
No. I mean, in this situation where they do not have a bond and they are not leaving the state of Maryland, how would we work out? How would we get that ratepayer their $200?
You would order Bollinger to pay it. I mean, bear in mind.
Okay.
Again, they're not going to go to court unless they can, if they don't have to. The court might even send them back here because they wouldn't have exhausted the administrative relief they've gotten.
Okay.
So they would come here first, as long as the commission retains jurisdiction over Bollinger.
So the bottom line is there's a decent chance that we could make that person whole without requiring them to get a bond.
That's correct, Commissioner.
Okay, thank you very much.
Yes, sir. Richard.
Again, I'm interested in learning more about this situation. So Bollinger, at this point, would continue doing business. They want to continue doing business in the state for the commercial and industrial sector. But if I understand correctly, they would be doing so without a bond. Is that correct?
That's correct.
Okay. Our practice is now to require a bond. Is that correct? I mean, if I were wanting to do business with the state of Maryland, in this, like Bollinger, and if I said, hey, instead of getting the bond, can I just pass the financial test? I'd rather just pass the financial test. Is that an option available to?
Yes.
Okay.
That is an option that remains available. If
Okay.
somebody comes in here with a license application and submits the appropriate financial statements, and they show that that company passes the financial integrity test, then they don't get a bond.
Okay, and is that happening now? I mean, our practice is to require a bond, right?
It doesn't happen that often. It does happen on occasion. Most companies just choose to get the bond because it's simpler and faster, and they don't, and they're not submit, they don't. Right. And Mr. Herbert just reminds me that brokers do have to have a bond, so it's required for brokers, but that bond is a $10,000 bond. But for supplier licenses, they are not required to get a bond if they pass the financial integrity test. If they, in most cases, they just get a bond. It's simpler, I suppose. The way to
Okay,
put it.
so I mean, is this something that you let people? I'm just trying to understand. Are we being consistent here? If in doing business in Maryland, is everyone aware that they could pass the financial integrity test and not have a bond? And or is this sort of like, oh, well, we just discovered by rereading our COMAR that in fact they don't have to have this.
I think most people are, in fact, aware of it. I believe the application form says, lays that out for people, as well as the commission's website,
Okay.
where they explain that, so that they are aware of the option. And like I said, it does seem that people do occasionally.
Okay, I just want to make sure we're being consistent, because this is the first I've heard about this financial integrity test as, in lieu of a bond in my time here. And I guess the other question would be, I mean, maybe this would be a time to say, okay, well, this is our practice now, Bollinger. If you want to continue doing business, since you want something from us, you want this amendment, we would like you, per practice, to now have a bond. I mean, is that something that it could be an option to us now, or would you rerun the financial integrity tests just to make sure that they still, are entitled to this?
We could certainly ask them for financial documentation to rerun the financial integrity test. And if the commission wants them to have a bond, the commission can require them to do so. Although I think it would be wise of the commission to change what's written in the application. If you want to change that policy, you would want to change what your public statements on the subject.
Okay, yeah, I'm just trying to understand the situation we're in, because again, I haven't heard about this, the circumstance about the financial integrity test as in lieu of the bond. So anyway, since I support the chairman what we're doing today, but maybe we ought to think about that when we're doing an amendment. Maybe we ought to reevaluate the company as far as ensuring that they still qualify for this financial integrity test if we're not going to require per practice a bond. So anyway, that's just an opinion.
So
Thank you.
I'd like to get a little more clarity on the financial integrity test. Is that in the COMAR?
Yes, actually, it is in COMAR. It's written out in full in the electricity supplier sections of
Okay,
COMAR.
and what does it provide?
I think I would probably need one of the accountants to explain that. I'm not very versed, but basically it's a positive financial cash flow and some level of equity.
So if we were to eliminate the financial integrity test and just simply require everybody to file a bond, we would have to make changes to COMAR to do that?
I think it would be appropriate, yes, if you were going to do that. I would say, I mean, going back, and this is going back a ways, that the bond was never intended as a consumer protection thing, except as a last resort. And that's the reason for the explanation, for the language that's in COMAR and in the bonds, laying it out that way. It was intended to allow the commission and other state agencies to obtain payment of obligations to the state. Consumer protection, for one, I think there was recognition that claims against the companies would be fairly small to begin with. But if the bonds, there was also, if I recall, a sentiment that if you were going to use the bonds as consumer protection bonds, you really, and if that were to be their primary purpose, you would want a larger amount than the $250,000 that was set at the time. they were never really intended as that, with that as the primary purpose.
Okay.
Okay, so
Mr. Chairman?
oh, wait a minute. All right. So Commissioner Linton, go ahead. If you got a question, go ahead before I move on.
If you're going to move on, that's
No, if you got a question, go right ahead. So
well, no, I was just going to say that I was comfortable with the approach you were going to suggest, which is that we proceed with a more of a general proceeding. I'd note that there aren't any suppliers here today, so they would, the ones that are interested in remaining in the residential market would be happy with giving us some insight into the best way that could move forward for them from their perspective, bond versus financial test. I can tell you that from Bollinger's perspective, from a Bollinger type supplier, as well as many of the other ones out there, there's very few that are going to resist paying a customer a couple $100, going all the way through the district court process, coming all the way to the commission for a bond. If you get to that point, that's a supplier that's already well beyond being active in Maryland. And we've had a few of those over the years, but and we have one of them that never paid the bill. It's probably several $1 million by now, and we're never going to find them. So these bonds weren't really designed to cover customer debts like that. If I remember correctly from the statutes from years ago, if the commission assesses a fine to a supplier, it's got to go to a fund. It's not something that we can have a cut. We can say, Mr. Jones, you get a certain amount of money, Mr. Smith, you get something else. So if they work through the Consumer Affairs Division, maybe they can get a refund that way directly from a supplier, but it's not we don't have a judgment type enforcement authority as a commission. So we certainly can fine a supplier, but it's not for individual customers like that. But I think an individual process like the chairman recommended earlier would be fine. This is not a complicated matter we can't resolve.
Good morning, Commissioners, if I may. Milan Tekle-Mikhail on behalf of the Maryland Office of People's Counsel. I just wanted to add a bit of a caveat. I think in the Smart Energy case, a recent order was issued by the Commission where Smart Energy had a $250,000 bond that I think the Commission ordered the Smart Energy to use that bond to as a portion of refunding and re-rating customers, if I'm not mistaken. So it's not a conclusive matter that the bond can never be used as a way to address customers' concerns. The Commission could use that. I'm sorry, go ahead.
I was just going to say, in the Smart Energy case, the Commission also ordered an additional bond in the
Correct.
amount of $2.5 million as well.
Correct.
It was a case. There was Smart Energy as a company had very widespread abuse.
no, I understand, and they're kind of the outlier, the poster child of what's wrong with this industry. All right, so what I want to do is this. As we said the other week, I need you to get together with OPC and see if we can come to some agreement as to how to deal with this legacy, residential customer legacy issue. If the two of you can't figure it out, then bring it back before us and we'll figure it out. But the next thing I want to do is I do want to send a notice out to all of the retail suppliers, because I guess we're contacting them anyway about the relicensing situation, and get them to decide whether or not they want to stay in the business of offering services to residential customers. If they don't want to do that and just want to remain as commercial retail suppliers, then let's do some sort of rulemaking that applies to all of them regarding these legacy issues with residential customers if they had them, instead of having to do this on a one-by-one basis over the next couple months. So with that, I want to defer the Bollinger issue, and I guess the question I got, does this impact item 5? Because they want to do the same thing, right?
It would not impact item 5 in the sense that Maryland Energy Advisors has a bond and they're keeping it in place.
I see. Okay, so we can deal with item 5, even though we're not dealing with item 4. Okay. All right. Okay, regarding item 5, I move we grant the company's request and remove the permission to serve residential customers from its electricity and natural gas supplier licenses. Commissioner Linton,
Aye.
Commissioner Suchman,
Aye.
Commissioner Barbat,
Aye.
Commissioner Richard.
Aye.
I vote aye.
The final item on today's agenda is from Potomac Electric Power Company and Delmarva Power and Light Company. It's revised tariff pages, a language update to their Maryland electric service tariffs.
Good morning, Mr. Chair and Commissioners. Drew McAuliffe on behalf of staff, filling in for Alessandra Lee. I also have Assistant Staff Counsel Ruthie Herman with me, who will provide some brief comments when I'm complete. On April 14th, 2025, Pepco and Delmarva Power and Light filed revisions to the payments and returned check sections of their tariff in order to formally incorporate the company's no check accepted policy. This policy, which has been in place since at least 2015, is currently published in both companies' At Your Service customer guides, which was provided as an attachment to staff's fuck sheet comments. The policy restricts a customer's ability to pay back a check after 2 return check payments have been processed in a rolling 12-month period. The restriction remains in place for 12 consecutive months from the date of the last return check. And these tariff filings are governed by Statute 4202A and 4203A of the PUA. And just to provide some background, the company notified staff that it planned to revise its tariff language to align with the company's customer guide when Delmarva Power filed its reply to staff's direct testimony in case 9727, which is currently in a phase 2. Case 9727 phase 2 is an active matter that is currently being litigated before a public utility law judge, and the evidentiary hearing for phase 2 is scheduled tomorrow, May 15th, 2025. The Assistant Staff Counsel, as I said, Ruthie Herman, will briefly address the case after my opening comments. During the investigation of Case 9727, staff discovered a discrepancy with a potential for causing confusion between Delmarva's At Your Service guide and their tariff regarding the no checks accepted policy. Therefore, staff filed direct testimony in Case 9727 on November 15th, 2024, which included several recommendations, one of which was that the Commission direct Delmarva Power to update its tariff language to be consistent between the tariff and the At Your Service guide. Staff was not aware that Delmarva Power and Pepco plan to file this updated tariff before the case concluded. However, now that they have filed the updated tariff language, staff has no issues with accepting it at this time. And I'll turn it over to Ms. Herman.
Good morning, Chair and Commissioners. Case 9727 is in active litigation. We haven't had the trial evidentiary hearing. That's tomorrow. My witness is going to be sworn, and I'm going to offer items into evidence, and that hasn't happened. So I'm just going to offer this recommendation that we not talk about the case here or any of the facts of the case so that we don't disturb the integrity of the litigation. And thank you. Number 2, you have to decide today about this tariff. According to the statute, you get 30 days from when they file it. If no action by this body, it goes into effect. You can just deny it. You can accept it. You can say rewrite it, but you got to do something today. And pardon my direct statement that way. And last, I have to concede that one of the documents filed into the case, it just it's in the docket, it's public record, not get into evidence, but said that they plan to file this tariff sometime in, I think, second quarter of 2025. So if the company says that, I have to concede that's right. Did I think that they were going to do it in the pendency of the case? It didn't occur to me. But now that it's here and we've thought about it, it's consumer protection language. It's good for consumers and actually brings them into compliance with COMAR, which requires that everything you talk about in your consumer pamphlets has got to be in your tariff. And that is 20.30.04.01. So it brings them into compliance. It's a good consumer language, and it doesn't preclude the judge in the case from writing a proposed order saying, well, I want it updated here. I want this tariff updated here. So there's no harm there that can't be resolved. Thank you.
So, any questions of staff? Actually, I got one. So this policy, does this mirror what happens with the other Exelon companies and also Potomac Edison, or does everybody have different policies?
So obviously PHI would be aligned. I'm not positive. So obviously we're not supposed to talk about the case, but the case has been limited only to Delmarva. We can get in, look into that for you, but it is common for the utilities to be charged a fee by whoever their payment processor is. If they have to send back payment, things like that. So it's not. This isn't an uncommon occurrence to, charge customers for just say a bounce check, for example, that kind of thing. But I'll have to look into that and get back to you. To see if they have the two checks. Sorry.
Sure.
Your Honor, if I may, Matt Seegers appearing for both Pepco and Delmarva Power. This is a practice that is used by all of the PHI companies. I can't speak to the other Exelon companies, but I can also say that this practice is currently enshrined in Delmarva Power's, in our tariff in Delaware. So, but it's used by all the PHI companies.
Alrighty. So,
Good morning, Chair Hoover and Commissioners. Isaac Lindenbaum on behalf of the Office of People's Counsel. The Commission should not approve DPL's requested tariff revisions and should instead defer consideration of the requested revisions until after Case 9727 has concluded. As staff and OPC's comments note, 9727 is an ongoing case with an evidentiary hearing tomorrow that in part addresses the no checks accepted policy. In DPL's tariff revisions here, if the Commission does wish to approve the proposed tariff revisions, OPC proposed additional language to be included with those revisions that I'm also happy to discuss as needed. Thank you, and I'm available for any questions.
So, any questions for Commissioner Sushma?
So, Ms. Herman said that we actually don't have a choice and that we have to accept the language today. Is that? Do you have a response to that?
Yeah.
Unless I misinterpreted.
No, you were right. And Mr. Dean just reminded me, I didn't say you have to accept, reject. You can also suspend. What you can't do is do nothing. So I'm sorry.
Okay.
Thank
Okay.
you,
So we have
Mr.
to
Dean.
do something.
Yes, thank
Okay,
you.
Thank you.
So
All right.
then I guess my response to your question would be to suspend the tariff revisions, and that would be the action the Commission.
Okay, and then, Ms. Herman, as long as you're up there, what would be the impact if we were to suspend it in terms of the proceeding that's beginning tomorrow?
I don't know that there's any.
And if we were to accept it, would it have any implications in terms of the proceeding that's beginning tomorrow?
None that matter.
Well, but sometimes you don't really know what
Right.
matters.
No.
So it won't have any impact on the proceedings that are.
It won't impact the integrity of the proceeding. I'd like to answer you that without.
I don't
being-
really know what that means. So I mean, is it going to weigh on how the judge rules on certain issues?
I am not sure I understand your question. So I'm
Well,
not sure if
I don't know what the proceeding is tomorrow.
Yeah.
So what I'm concerned about is that if there is an ongoing case, I just want to make sure that it's not going to have an impact, what we're doing today, on this case.
Thank you. So Mr. Spivak just gave me a suggested response, and this does make sense. It could have a persuasive impact. It could.
Okay, that's. I mean, I feel like I'm blindfolded and I have headphones on. I don't know anything about the proceeding, but and not knowing anything about the issues underlying the proceeding, I just and if it's not if suspending it won't have an impact, I don't see that we have a choice other than to suspend. But I'd welcome Mr. Seegers.
Yeah, actually, so we turn to Pepco and see what
Thank you very much, Your Honors, and good morning. I think it is very important to make sure that we are not conflating two very different issues here. The ongoing matter in case number 9727 does not concern the no checks policy. What it concerns is right now in Delmarva Power's tariff, if a customer, if they make a payment with a check and that check is returned for insufficient funds, our tariff allows us to impose a $15 fee on that customer. What our tariff also says is that if that is the first return check within a 12-month time period, then Delmarva Power will waive that return check fee. Unfortunately, the way our IT system was configured, our IT system was not doing that. That is the purpose of the ongoing proceeding in 9727. And actually, in the judge's his proposed order issued on July 24th, 2024 in that proceeding, he stated that the purpose of the proceeding is to determine the extent of Delmarva Power's non-compliance with its tariff provision regarding the waiving of the return check fee. There is no mention in the judge's order about the no check status. That policy has come up in the proceeding, but that is not the focus of the proceeding. So I do not believe that if the commission acts on this tariff language, if you approve it today, quite frankly, it will have anything to do with the hearing tomorrow or the proceeding as it goes forward. So I hope that provides some clarity. It's basically two very different issues.
All right, wait a minute. Okay, go ahead.
So if we were to suspend the language, so we're not approving it, denying it, what would be the impact on the PHI companies?
Well, as the PHI companies are not aware of anything in the Public Utilities article, nothing in COMAR or our tariff that it says we cannot engage in this practice or prohibits it. In fact, as staff indicated, we believe that this is a very good consumer protection mechanism. Essentially, what it does is that it prevents a customer from accumulating a larger arrearage that will ultimately have to be borne by our customers.
Okay, so I guess my question is, what's to stop if we were to suspend it and ask you to come back when the proceeding is finished? Whatever this proceeding is tomorrow, what would be the impact on the PHI companies?
As long as it is clear that we can still do this practice, I don't believe there would be any.
Well, I don't know that we're weighing in on whether you can or can't do the practice. We're just weighing in on whether we should be approving the tariff language. I'd be uncomfortable about weighing in on whether a practice is appropriate or not. I mean, I need much more information on that. But what I'm asking you is that if we were to suspend consideration of this until after the proceeding is finished, so that, because based on Ms. Herman's last statement to me, it could have an impact, what would be the impact on PEPCO or PHI companies?
I don't believe there would be an impact, Your Honor.
Okay.
The only impact, I would agree with Mr. Seegers, but the only impact is really on customers because it'll still be somewhat confusing because the tariff does not clearly.
Well, the problem is I'm confused. So I just, I just worry that we could do something. There could be unintended consequences to what we're doing today, and if we don't have to have those unintended consequences staring at us, and we could just take this up when your proceeding is finished, then we don't risk the unintended consequences.
Yeah, I mean, the judge would be free to make any decision the judge wants. I would agree with Mr. Seegers. This is tangential. Staff discovered that the tariff and the At Your Service Guide were not exactly aligned. So that's why we made that recommendation in that case. But I would agree with Mr. Seegers. This is about the return check fees, that proceeding. This was kind of tangential. We noticed it, and we thought that should be fixed to help customers, not PEPCO or PHI. This is to help customers.
Well, but OPC represents customers, and they clearly
Well,
think this is a
obviously
problem.
we disagree with
So
that.
I'm just,
This is
but
customer
it doesn't sound like there's gonna be, it doesn't sound like there's gonna be a big problem if we suspend it and just wait until after the proceeding is finished.
No, and that was my point, that the only party that would be harmed is
And
customers.
Mr. Lindenbaum, you'd be okay with that?
Yes, Your Honor.
Okay, that's all I have.
May I be heard for one more moment?
Sure.
Thank you. So Mr. Spivak just reminded me that the suspension can last for no more than 180 days.
Wait, what do you mean the suspension?
If you suspend the tariff today.
Oh, I need
Yeah.
it. Okay. Now I
Thank
get
you.
it. All right.
You can simply deny it.
Well, but can we suspend it, can we suspend it a second time? Or, I mean, PHI would have to come back in 180 days, but at 180 days, if you're still in the middle of your proceeding,
I think the proceeding will be over well before 180 days.
Okay.
The 100, generally speaking, no. I mean, you have the suspension period is laid out in the statute, and that's you get to do it once, and if you don't finish the case by the end of that, then the rate in question would go into effect subject to as a temporary rate conceivably. But what I was just going to say is this is not a dollar rate. This is a
No, I
category of rates terms.
I understand. I just,
Right.
we don't want to, 6 months from now, or 3 months from now, somebody coming in and saying, well, there were unattended consequences to your approving this that we didn't anticipate. So it doesn't sound like we have to, I'm, right.
No, you can suspend it for up to 180 days, and if you want to specify that the company that this item be revisited once there's a final order in case 9727, you can do that. Although again, you would assuming that order comes within the 180 days, and it most certainly should.
Okay.
Mr. Linton.
Yeah, thank you, Mr. Chairman. So I have a couple questions for the company. And you noted in your filing, and good morning,
Good morning. Good to see you again, Commissioner.
public education regulation. How long has it been in there?
Oh, it's been in there for a number of years, and I'm trying to find out exactly since when. But this is not a new practice, Your Honor. We've engaged in this practice for at least since 2015.
Okay,
So-
so it's well over a decade old, if not longer.
Yes, that is correct.
Okay.
Your Honor.
And it hasn't been in the tariff during that period of time.
Not in our Maryland tariff, no. As I indicated to Chair Hoover, it's been in our tariff in Delaware. But it has been disclosed each year to our customers in the At Your Service Guide, which goes out every year. And when the issue arose in 9727 and staff recommended that we incorporate it into our tariff, we said, of course we will. We have no issues with it.
So my next question was going to be, why are you filing this now? Especially since there was a proceeding that's going on, that's, I guess, starting tomorrow. So is it because the staff asked you to make the filing at this time?
Essentially, yes. And in our responsive testimony that we filed, we did indicate that we were going to file this during the first quarter of 2025. And actually, we were a little bit late in getting in our filing. We didn't make it until April the 14th. But that is why we filed it, Your Honor.
Okay, so if you've been doing this now for a decade, and the commission, we know we have this in front of us today, we have to take some action today. If we don't approve it, and we don't deny it, and we just suspend it, your practice is going to be the same tomorrow as it was yesterday.
Yes.
You'll still be using
Yes.
the same practice.
Yes. As I said before, we're not aware of any law that says that we can't engage in this practice. And as I also said before, we think this is the kind of thing that we should be doing because it helps us to prudently manage the uncollectibles that will have to get rolled over to all of our customers.
All right, thank you. Mr. Seeger. So a quick question, follow-up question for staff then. If you raise this with the company and encourage them to file this tariff to try and address some consumer concern or conflict, and we suspend it, but it's still being carried out, have we addressed the problem, or is it still a problem, or is it something that can wait?
The tariff language? Is that
Well, you asked you suggested that the company make the filing,
Mhm.
and they have.
Mhm.
But if we suspend it or don't take an action, the reason you suggested it was because there was some concern that you had.
Yeah.
I guess my question is, have we addressed the concern, or is it still something that's unaddressed for some period of time?
If you don't approve the tariff, we think it would still be unaddressed because the At Your Service Guide clearly explains the no check policy, whereas the tariff does not. So that's why in our testimony we requested that Delmarva include it in their tariff so that the two documents match, and it would eliminate customer confusion. Because this case started as a complaint against a return check fee that a customer was receiving. So we thought if the tariff was cleaned up, maybe it would address some future issues as well.
So aside, with the exception of and I don't want to get into the case that's pending now, has staff noticed that there's been other instances of consumer confusion about this issue to the point that the commission needs to take some action now? I don't know what it will be, but or is this something that can wait?
I mean, that's really up to the commission. Obviously, it hasn't been in the tariff. I mean, staff is always concerned about customer protection. So when we found the issue, we thought it should be addressed as soon as possible because, again, we think it's kind of tangential to the case. It's not directly impacted by the case. So, so in regard, obviously we can't talk about specifics of the case, but we're more reviewing the return check fee. So we don't have any specific examples of customers calling or emailing or whatever saying that we didn't know that there was this policy. I couldn't speak to that. That was not reviewed during the case specifically.
All right. Thank you.
Sure.
Thank you, Mr. Chairman.
Okay. Just so I understand how this policy currently works. So if I send you a check for May's usage and it bounces, then you have the ability to charge me a $15 fee for the fact that I sent you a check with insufficient funds, but your policy is to waive that fee?
If we're talking about the Delmarva Power tariff, Your Honor, the way it works is that if you send a check in and that check bounces, then what the tariff says is that we can impose a return check fee of $15 on you. However, if this is the first return check in a 12-month time period, then we are going to waive that return check fee. If within that same 12-month time period, if you make another check payment and that check bounces, then we would, one, impose the $15 return check fee, and two, we would place you on a no check status, which says that from the time of the second return check for 12 months, you can't pay your bill by check. You would have to use, I've got a list of other options of where you can pay by cash, certified check, money order, credit card, debit card, wire, direct debit.
So, well, let me ask you this, though. So the debit card's tied to your checking account, correct? At least that's my assumption of how most debit cards work.
I would think so, yes. So
So-
I mean, that would be an option.
Yeah, but so hypothetically, if I paid with the debit card and, didn't have sufficient funds, I mean, is that the same thing as a bounced check?
I'll.
So-
It would be denied.
So you can't, so while you can write a check that.
Well, I mean, I guess the situation would be your check bounced and then your paycheck came in, and so 2 or 3 days later there would be sufficient funds and you'd be able to do the transaction at that moment.
Okay, all right. So, all right, apart from that, I guess the other question I got is, what's the rationale behind the 12 month, if this happens twice, what's the rationale behind the 12-month ban, so to speak?
I think what the rationale is just to make sure that the customer doesn't unnecessarily accrue an arrearage by using another form of payment. When they pay by check, it's about as we explain in our filing, it takes about 10 calendar days for us to send that to our bank, have it clear, and then if there's insufficient funds, it comes back to us. During that time frame, the customer, they may, their arrearage, it could keep accruing. So by the 12 months, it's a 1-year time frame. You can think of it as kind of like a probationary period. But once they clear that 12 months, they can start using checks again. That's kind of the rationale for using that time.
During that 12-month period, they've got to use all these other mechanisms, either credit cards or cashier's checks or things like that.
Correct. Or, if they're having issues paying their bill, we are always happy to work with them to refer them to energy assistance. That's another option. So there are a whole there's a whole list of ways that they can pay their bill other than by check.
Okay. All right, so I guess what I want to do is actually suspend the tariff. And how long do we have to?
180 days.
Okay.
I'm sorry, Chair Hoover, 180 days.
Okay.
Yeah, thank you.
All right, I move we suspend the tariff for 180 days. Do we have to state the date or just 180 days from today? So,
That's
okay.
good. Thank
All right.
you.
Commissioner Linton.
I know where we want to go with this. I appreciate what you want, the proposal behind the motion. And I think we're on the same page. I'm just concerned about what this means. If the company has filed a tariff, it's in effect unless the commission makes a decision on it. And if we're suspending the tariff, that means you can't carry it out anymore. But it's my understanding that you're going to continue carrying it even though we've suspended the tariff.
That's correct, Your Honor.
Are we suspending the tariff or is there anything else in this tariff? It's just this tariff.
Yeah, it's just this. It's what they proposed today. Yes.
Yeah, we're just trying to freeze things. So.
Right. That's what we want to do. But they've
No,
proposed,
but it's revised tariff pages. So there is an existing tariff.
well,
So
that's-
we're not suspending the tariff. We're suspending the new language
Yeah.
in the tariff.
But-
I just wanted to be.
Yes. But the new language is for this policy, the check policy, which wasn't in there before.
Can we just vote
Correct.
for the status quo so they can get through the case?
No, I actually think, Commissioner Linton, just to be clear, suspending it has no impact, and I think maybe we can have that as part of this, it's going to have no impact on the current policy of the companies. We're not weighing in on that, and we're not, the suspension only relates to the proposed language, and only because there is an existing proceeding that's ongoing
All right.
tomorrow.
Actually,
I think if I may make a friendly amendment, what I would suggest is that the company withdraw their filing.
They don't.
And by withdrawing it, the commission hasn't suspended anything. We haven't voted on it. You haven't. Your policy remains status quo. Perhaps we could even encourage this issue to be addressed at the case if it isn't already, and I'm not sure if that will or not. I don't want to taint anything, but
yeah.
But I think the problem is that by you filing it, it requires us to take an action.
Well, but I think we've got, the only problem is I think Mr. Spivak's going to tell us that we have to do something today.
Well, no. I mean, if the company withdraws its tariff, that would resolve the issue until the case withdraws the filing. I think actually Commissioner Linton may be right on this, that his concern is that if the tariff puts into formal effect a policy that they've been carrying out all along, and if you suspend the tariff language, that essentially could be read as suspending the policy.
Yeah, I agree too. And that's why, even if we made it clear that that's not what we're intending, just by the action, it could have. Right.
Exactly. So it's probably so withdrawing the filing is probably the
Which
best idea. And
Seems to me the only reason you filed this is because they asked you to file it. Correct?
That is correct, Your Honor, and we have no issues withdrawing the filing. That seems to resolve everything.
All right. I think that works. I think that works for us, and that works. And I take it that'll work for OPC. So. Okay. So with that, I guess we're adjourned.